I'm Gary Feldman.
I'm Tamsin Kaplan.
So we're Davis Malm. We're two of the lawyers in the employment group. Welcome to our presentation on some new developments in employment law. Wage Act issues. The Massachusetts Wage Act, fraught with danger for employers. Wage Act provides if there's a violation of even a de minimis amount, you're looking at treble damages automatically now. You're looking at attorney's fees, and you're looking at potential retaliation claims. There was a recent decision report in Massachusetts which led to a verdict and judgment in favor of an employee of over almost $500,000 on a Wage Act retaliation claim, where the differential in the Wage Act, what the employee was claiming, amounted to about a 50-cent per hour discrepancy in the hourly wage and the hourly rate. And the employee apparently made a very modest demand to get the matter resolved. The employee ended up being terminated. The employee ended up bringing a retaliation claim. So the 50-cent, the differential in the wage payment between what was found to be due the employee versus what the employer paid was very small, amounted to just a couple of $1,000s. But because the employee was then terminated and successfully claimed retaliation, was able to get back wages, which were then trebled, and added attorney's fees. So you had basically a dispute over 50 cents or 50 cents an hour turned into a $500,000, close to about a $475,000 judgment against the employer under the Wage Act. So caution everyone here, you don't want to run into any trouble with the Wage Act because the penalties against the employer are significant. So where do we see a lot of wage? We don't see many Wage Act disputes like that where there's a disagreement as to what the agreement was to be for the compensation. We see it in terms of misclassification issues. Employer classifies a worker as an independent contractor. Turns out the person should have been properly classified as an employee. They weren't paid minimum wage, they weren't paid overtime because they were treated as an independent contractor. That can lead to a Wage Act issue. Deductions, chargebacks to the employee either during or most frequently at the end of employment can lead to Wage Act violations. So here, your company provides your employees with a laptop computer and a mobile device. The company is permitted to deduct the current fair market value of the equipment from the employee's last paycheck if the equipment is not returned or is returned damaged, true or false. How many of you think you can deduct the value of the equipment when the employee who either quits or is terminated and runs off with your laptop and your mobile phone? No one thinks you can do that. Okay, you're all right, you cannot do that. That would be a violation of the Wage Act. You are absolutely prohibited from, even with the agreement of the employee, of entering into any special contract that would deduct or withhold earned wages. You may only deduct pursuant to a valid attachment, that's a court order, a valid assignment, or what's called a valid set-off. We'll talk about what a valid set-off is. So your company is a retail store, and you have a policy that employees may purchase items on credit at cost and then deduct the amounts from the employee's paycheck on a weekly or by paycheck pay period basis. Comes to the end of the employee's term with you, and there's still amounts due on the employee's purchases from the company. You have a written signed agreement that provides for the recovery from the final paycheck. Is this a permitted practice, true or false? Everyone think this is a permitted practice? Yeah, that is true. That is a permitted practice as long as you have, it's just like a loan to or an advance from an employer to the employee. As long as you have a written agreement that's got a stated amount signed by the employee, you're entitled to make that deduction from the final paycheck to either recover the balance of a loan or an advancement that the company made to the employee, or to recover the value of goods that the company sold or permitted the employee to purchase. The difference between this and the previous slide was this is a liquidated set amount. It's not subject to the discretion of the employer in determining what the value is. So the previous slide I told you is that you gave the employee at the beginning of their employment a laptop and a mobile phone, mobile device. Say 2 years later, the employment ends, the employee runs off with your equipment or returns it in a damaged state. You make the determination, okay, the current fair market value of that device and that computer is X. That's an arbitrary, well, it's not necessarily arbitrary, but that's a unilateral determination by the employer. It's not liquidated, it's not a liquidated amount. It's not determined by a court of law, even though the employee has signed an agreement at the outset of the employment saying, if I don't return the equipment or return it damaged, you're entitled to charge me for your determination of what the fair market value of that equipment is at that time. That is not a permitted practice, and that would be a violation of the Wage Act. The difference between that and an advance or a loan to the employee or the sale of goods to the employee is that you have a written agreement, and then you have a sum certain that does not need to be judicially arbitrated or subject to discretion of anyone at the time. So there was within the last 6 to 12 months, the SJC in Massachusetts had a case, a trucking company who had a policy that if any of its drivers, I think it was a waste delivery, a garbage pickup company, if any of the drivers damaged any property, they had the option of either being subjected to disciplinary action, warnings, performance ratings, even termination, or paying back to the employer the damage in the amount determined by the employer. And the employee had the option either take the disciplinary action or take the set off on the payment terms. And the SJC concluded that was that was a violation of the Wage Act because it was the employer alone determining what the value of the damage was, and it wasn't subject to a judicial determination. So Wage Act issues. Yes?
We had a laptop agreement, but the employee is paying every week towards the laptop. So when they leave, it's agreed that they can either we pay them the value for what they put in, or they can pay us the remaining value. Is that okay?
Yes, okay. Because you've got a set amount, and that's an addition. That's similar to an advancement, yeah, okay, or selling of goods. You've stated it. Where the case where the SJC came down and the waste haul company was that you've got the employer making a decision unilaterally, A, whether or not the driver was at fault. So they only applied this when they determined that the driver was at fault, and then B, making the unilateral determination as to what the value of the damage was.
They didn't use their insurance?
What's that?
When they use their insurance?
Well, the court said there's got to be, in that situation, there's got to be a judicial determination. So the bottom line was the employer could not take the deduction, charge the employee as against their wages. If the employee was negligent, was at fault, caused the accident, they could go to court, sue them, or subrogate, have the insurance company sue them, and then establish their fault and the value. But the employer could not, on its own, without any means of redress for the employee, do that and then deduct that from wages. The SJ in Massachusetts, as in most states, wages are held to be sacrosanct, and it's very limited situations in which an employer can interfere with the payment of wages, particularly on a final paycheck.
So if someone you're letting an employee, other than go to court, is to do a disciplinary action with them, it sounds like, if they damage a property of the company?
You could do that because you're not interfering with their wages.
Right.
So if an employee, yes, you have a driver or equipment operator, there's an accident, damage to the equipment, the company's entitled to investigate and determine not if that employee was at fault. Maybe he or she was impaired at the time, wasn't following safety regulations, caused damage. That's certainly a matter of appropriate disciplinary action. but you can't go into their paycheck and make the company whole by taking away from their wages.
Can I just add to that? I'm sorry.
Go ahead.
Adam, that's a really good point. And whenever we deal with Wage Act issues, I always tell my clients, no matter what, you have to pay people for the time they worked. So say, for example, completely other issue, and another totally different issue that arises under the Wage Act, somebody is working extra hours without your permission, even though you have a policy that they need explicit advance permission to work extra hours. It's a non-exempt person. Do you have to pay them overtime? Yes, you have to pay them for every minute that they worked. Can you discipline them because they violated a policy because they did that work without your permission? Yes. Can you terminate them for that? Yes, but you have to pay them.
Gotcha. Thank you.
What about the use of a corporate credit card where the employee gets reimbursed personally and then is responsible for paying the corporate card back, and there's no pre-existing policy in place that it can be withdrawn?
If there's no pre-existing policy signed agreement by the employee, I haven't looked at that, I would say no. I would. The only situations in which the courts have found that it's a valid set-off would be where there's a signed agreement by the employee saying any balance due at the time of my employment ends you may take from my paycheck, signed by the employee. So going back to this example, one last Wage Act issue. So here you've got the employee purchased items on credit at cost from you, comes to the end of the employment, there's still an amount due. You've got a written agreement that you may deduct any such amounts from the employee's final paycheck. Now you have the situation, if by making that deduction and balancing out that debit account, can you do that if the deduction reduces the amount to be paid to the employee in their final paycheck below minimum wage for the hours worked? Anyone think that you can do that? You can take the deduction even though it'll result in a final paycheck that'll result in a payment of wages less than the minimum wage for the hours worked? Unclear. Trick question. Such a set-off is valid under the FLSA, which is the federal law. So under the FLSA, where you've got a valid set-off, a signed agreement by the employee allowing you to make such deductions from the final paycheck, you can do that even though it reduces the net amount to the employee below minimum wage. However, because of Evie's hard work, we know that in Massachusetts, the Attorney General's office, which is the enforcement office for Wage Act violations, have not yet issued an opinion under Massachusetts wage and hour law, following up on that court decision I told you about with the waste hauling company. And the last information we have from the Attorney General has issued a written guidance on the Wage Act. So last we heard they are reviewing that and updating that to look at how the SJC's language in the camera decision would affect the ability of the employer to make the full deduction even though it results in a less than minimum wage payment to the employee. So stay tuned.